today. My name is Bill Tam. I have the honor and privilege of being one of the co-founders of the Digital Technology Supercluster. It's great to see so many familiar names and faces on this Zoom call. I'm sure you're all getting accustomed to having these sort of workshops run live on video. So thanks very much for joining us today. For this workshop, just as a reminder that we are going to record this for all those who were not able to join us for this, and then we're going to post it on our website. And if I could just ask in terms of, I'm sure you're all very accustomed to the etiquette now for these sorts of things, if I could just ask you to mute your lines just to avoid any of the feedback during the presentation, that would be great. And our goal is to have lots of conversation. So in order to do that, we'd ask if you have some questions to type it into the chat box. And what we'll do is we'll run a process for Q&A, and I may ask you to unmute your line so that you can ask your question to the panelists as we go through. So a bit of, by way of maybe kicking off this session, because many of us are located in Vancouver, I'd like to first acknowledge that we are gathered on the, at least virtually, on the traditional lands of the Musqueam, Squamish, and Tsleil-Waututh nations. And what I'd also like to do is formally welcome our guest speakers today. We have Roch Ripley from Gowling and Paul Banwatt from Gilbert. They are going to be fantastically entertaining, and we're going to have a very rich conversation about what it means to have collaborative IP development, and particularly in the context of Supercluster. And what we'll have is probably about a 10-minute presentation, which will help to set some context. I'll then add a few comments around what IP looks like in the context of Supercluster projects. Then we'll open it up for some questions. Please feel free to add questions in the chat box as we go through. And then we should have a rich half an hour or so to go through some Q&A with the panelists. So without further ado, what I'd like to do is introduce Roch, who's going to kick us off, and maybe you can share a screen. Roch, over to you.
Sure, it's nice to meet you all. I think Paul, you're the one who's going to be kicking us off, right?
Yes, I will start us off. I appreciate the double introduction, though. Thank you. Hi, everyone. My name is Paul Banwatt. I'm a lawyer at Gilbert's LLP. And if you'll just bear with me for a second, I'm going to attempt a screen share. Okay. Hopefully you can now all see the title page of the presentation. Is that working all right, Annika?
Yeah, you're good.
Great. Okay, so I'm going to start us off talking a little bit about grounding IP collaboration by stratifying the relevant IP in collaboration agreements. And it's hopefully more exciting and interesting than that sounds. Basically, what we're talking about here is, a first step of how to think about the IP that might be created or implicated in a collaboration, and that needs to be dealt with in a collaboration agreement. Trying to move us ahead. There we go. So I won't belabor this point when we're talking about collaborative engagements. We're talking about joint efforts between multiple parties, like you have at the Supercluster frequently, and they can include obviously various combinations of government, small entities, large entities, colleges, universities, not-for-profits. Now, one of the fundamental parts of a collaboration agreement is that it needs to address the intellectual property rights. And the key to this is that the way that we believe you should think about those IP rights is by first identifying and stratifying them by the timing and circumstances of their creation. So I'm going to give you a sense of what I mean by that. I think a lot of people are familiar with the terms background and foreground IP. I will go over them again briefly in this presentation. Here on this slide, you see a sort of map of a collaborative engagement between two entities, entity A and entity B. Roch is going to talk a little bit more about the considerations that might apply based on who they are, whether you're a large or a small firm. We'll talk a little bit about that. But for now, let's just say there's two companies that are coming together to collaborate. They both bring something to the collaboration. So they both, have, maybe both, but at least one brings something to the collaboration. So they have data, or they have patents or copyrights that are going to be relevant to the collaboration between the two parties. That's their contributed IP or background IP. They create intellectual property through the collaboration. So, the outputs of the collaboration is the foreground IP. And then we're going to talk about these other two concepts that I think are dealt with less often. Sideground IP, that's related IP that's created independently by one of the parties. And then postground IP is IP that's generated or created maybe by one of the parties or by somebody else after the collaboration is at its conclusion. So quickly thinking about background IP, as I said, this is existing intellectual property assets that are held by a collaborator. Frequently, this is where a lot of thought gets put in at the beginning of a discussion of collaboration. I think that's appropriate. You need to protect what you have. You need to make sure that you're not losing something important to you by virtue of engaging in a collaboration with a third party. The things that you need to think about are the things that people do think about: background IP disclosure. Do you need to do a search of your IP for things that might be relevant? What kind of in-licenses you want to provide, and what kind of compensation you want to receive for the use of your background IP. In terms of foreground IP, here we're talking about the outputs, the things that you're creating. Again, this is where a lot of time gets spent in collaboration agreements typically. That's not surprising either. You're thinking about the outputs of your project, and you're thinking about what are we going to do, what are we going to create. And then, based on that, you're going to think about ownership and licenses, decision-making mechanisms about those created outputs, your revenue or profit-sharing mechanisms. An important one is obviously liability and risk sharing, who has to take on the risk and who is responsible for maintaining and enforcing IP rights. And then, dispute resolution mechanisms. Now, where I want to spend a bit more time is here. So, just to give you a little bit of background about our firm, we're our founder Tim Gilbert likes to call us a soup to nuts IP shop, and we that means we do litigation, we do commercial agreements, we do IP agreements, and corporate commercial work. And so one of the things that we noticed in recent years was that there is more and more of this collaboration going on between parties, and we wanted to start think about it and address it. And one of the things that we did was we set out to create a survey of all of the IP agreements we could find, both within our own data and within public databases, and see how things were being addressed, what was being addressed, what different terms were being used, what were the indemnification terms, what were the confidentiality terms, and how IP was being treated. And where we found a gap in a lot of collaboration agreements was in the treatment of sideground and postground IP. Now, why do these things matter? So sideground IP is related IP that's being developed independently by an entity. This comes up frequently in the case of a large entity. So, if we're talking about Microsoft, apologies if Microsoft's on the call, don't mean to call out anybody, but if you're Microsoft, you might have one team that's collaborating, engaged in the collaboration. You might have a completely separate team that's working on a very similar problem, and that may come up with very similar solutions. And if your collaboration agreement doesn't deal with the potential product of that other team at Microsoft, then you might be left in a situation where your co-collaborator has come up with a solution to the very problem you were trying to solve, and you might wonder what the rights are of the parties in that situation. Can Microsoft enforce those IP rights that they independently created against their co-collaborator? Are those IP rights automatically in-licensed? Can you terminate the agreement upon the creation of that particular solution by that independent team at Microsoft? Can either party do it? So it's a really important thing to think about. And it's a little bit hard to talk about it in the abstract, because you really need to think about what kind of sideground IP are we discussing? Is it data? Is it patented technology? Is it copyright? Is it a trade secret? And how might that impact our collaboration if it's independently developed? Similarly, postground IP is often left out of the conversation, and it's equally important. So here we're talking about intellectual property assets that are created after your engagement has concluded. So in a typical engagement, you'll say there's a start point and an end point, and once we're finished, we've got something, and now we go maybe our separate ways, or we have a joint vehicle. But the period of development is seen at an end. What happens if we're setting out to solve a particular problem, speeding up some kind of processing time? We maybe get halfway there, and then a year later, entity B comes up with a solution, or here in the graph, it's entity A, comes up with the solution to the problem that we were trying to solve. Is there any kind of license back? Is there any kind of use right? Are they able to enforce that IP against their previous collaborator? How are we going to deal with that kind of problem? Another kind of post-ground IP we can see is, let's say we set out to create a platform that allows users of the platform later to develop their own IP. Now, that might lead to the creation of IP assets that are relevant to the collaboration, but not necessarily by a collaborator. We might think about how those potential users are required to license back to the collaborators or provide rights to the collaborators or provide royalties to the collaborators. And we want to think about that kind of post-ground IP as well. So it really depends on the nature of your collaboration, but the important thing is relevant IP that's created after the collaboration is complete needs to be addressed as well. Sorry, my computer is freezing slightly, so hopefully we get to the next slide. There we go. And one thing I just want to stress is that these terms aren't codified or defined by any statute. You have to define them carefully as well. So when we're talking about background, foreground, sideground, postground, those definitions might shift slightly in your agreement based on the nature of your agreement, and you want to make sure that you've carefully identified them. If you can attach a schedule or a disclosure requirement of them, that's great. But the more narrowly we define those terms and appropriately, the more effective our collaboration agreement will be, the more we'll avoid future problems. And with that, I'll just say, a few key takeaways, identify the potential for each of these things with respect to each, consider the IP relevant issues. And then, I think Roch will talk more about this, but with respect to ownership, consider the interests of the parties in respect of each of those strata of IP. So that's all I've got right now. Hopefully that was short and sweet, and happy to keep talking about it as we go through today.
Well, thanks so much, Paul. Maybe with that, we can hand it off to Roch.
Great, thanks, Paul. Thanks, Bill. Can everybody hear me? Yeah, okay,
Yes,
good. Let me just share my screen here. And is that the presenter view or the full slide?
It's a full slide.
Okay, good. Okay, well, thanks again, Paul, for describing those different rights. It's going to be very useful as I go through my presentation. Just quickly by way of introduction, I'm a partner in the Vancouver office of Gowling's. I head the Vancouver office's IP department, and I'm happy to talk about these issues, which we see fairly frequently in the local market. There's our title slide showing 4 people in clearly pre-COVID times collaborating within 6 feet of each other, hunched over a table together. I'm very jealous. So let's move on from that. The 3 things I want to talk about very quickly: 1, what I call the supercluster effect; 2, certain business-oriented collaboration drivers; and then 3, various legal collaboration tools you can use to execute on collaboration. So the supercluster effect, what do I mean by that? Well, I've got here a diagram that shows 2 parties. I've called them Party A and Party B, with very large difference in bargaining power. Sort of your quintessential example is if Party A is a large multinational with a lot of money and customers, and Party B is an SME, perhaps closer to the S than the M, with some kind of novel technology. And what results in a difference in bargaining power? Any number of factors. Money is the most obvious one, but not the only one. Could be a desire to acquire a first customer. Could be a reputational benefit to Party B of dealing with an established player, for example. And to be clear, although the example on the slide is the large multinational having the bargaining power, that's not necessarily always the case. You may have the smaller company have more bargaining power if, for example, they have some kind of specialized technology or service that is very well protected with IP that the larger company needs. So the bargaining power differential can go both ways. And if the difference in bargaining power isn't addressed, what we often see are agreements that will result in collaboration where IP rights are held almost exclusively by one party. So if you have Party A being a large company with lots of money and Party B really needing that money to develop its technology, Party A may fund that technology, but all the IP rights and a lot of the commercialization benefits down the road will flow to party A. So party B, even though its business model may have started being technology development, really for this engagement became a services company to develop technology on party A's behalf, not initially what they had in mind. Conversely, the example I gave where party B may be the smaller, more specialized company, party A may come to party B and say, listen, we really need you to advance one of your key products out of turn because we need that solution and we're willing to pay for it. And party B may say, well, that's great. We're happy to do that, but you're gonna have to pay for it. And when you pay for it, we're not gonna just limit our solution to you. We're gonna make it available to everybody, and that includes your competitors. And because our technology is completely owned by us and we're the only ones who can do that, we can do that. So party A can get that, but they have to pay for it entirely and they don't have exclusive rights to it. So those are the two extreme cases that we can see. And the supercluster effect I've shown in blue there, really by virtue of the relationships and the funding and the culture that the supercluster brings, it shrinks that differential in bargaining power, which I think sets the groundwork for increased collaboration. And with that groundwork, what are some of the business drivers that can incentivize collaboration? Well, you may have two parties that have different positions in a technological stack. So one party may develop a platform, another party may develop an application, and you can collaborate because if the application party develops improvements relevant to the platform generally, they don't really have a big problem licensing that back. And conversely, if there is IP specific to the application, the platform company may be fine not owning that exclusively. You may have a general technology that has a specific application. So AI is being used right now to augment lots of applications. You can have an AI model, various kinds of neural networks of general applicability, and that can be customized for a particular solution, facial recognition or what have you. And it may be that the company that has the knowledge and expertise in respect of the AI model doesn't need to own IP specific, for example, training data that is specific to a particular application. So there may be ground for collaboration there. You have different territories, and that is pretty self-explanatory. You just carve up the world. And you can have certain parties operate in North America, another party operate in Europe, another party operate in Asia, what have you, and collaborate in that way, even if you are using the same technology and competing for similar kinds of customers in different geographical regions. You can have different market segments. So even if you have the same technology, the technology may be used to service different parts of the market. So in the news this week, Apple has been in the news. They announced earlier in the week they're going to be switching from Intel to their own silicon. Apple and ARM, they both design silicon, but they both collaborate very successfully. They have different business models. ARM doesn't license its processors directly to consumers. They license their processor designs to companies like Apple, and Apple goes to consumers. So they're able very well to collaborate, even though they're both in the business of chip design. And you may have different IP rights. So I mentioned earlier the AI example. You may have one party that wants data, could be training data in the AI example, doesn't have to be, could be user data for marketing purposes or purposes for product improvement. One party may want that, and the other party may want a different IP right altogether, for example, patent or invention rights. And trademarks and co-branding can come into play here as well. You may have one party that's not particularly interested in how to manufacture the product, but wants to be able to deal with a party with an established brand so as to facilitate sales. So some kind of distributorship agreement or what have you. And these, of course, can be mixed and matched, and they can combine in any number of ways. So once we've incentivized or identified some kind of incentive or impetus for collaboration, how do you execute on that using the law? So the overarching principle, I'll go through some examples, but I think it's important to emphasize that the overarching principle is you can generally do whatever you want. Take advantage of hundreds of years of Anglo-American capitalism and go and contract as you see fit, subject to really only a handful of exceptions. One question that comes up all the time, co-ownership versus licensing. Should I demand some kind of IP ownership right, or is it okay just accepting a license? Well, of course, all other things being equal, it's better to co-own than to license because ownership is inalienable. It can never be taken away from you. If you are a licensee, there is always a chance that that right can be abrogated by the licensor. For example, in case of bankruptcy, despite recent changes to the law, in the case of a true blue bankruptcy, who knows exactly what's going to happen, or depending on how an agreement is structured, if there's a breach of the agreement, the licensor may have a right to terminate a license. So yes, it's better to co-own than to license, but co-ownership's more difficult to paper. It's more complex legally. The rules on co-ownership can vary by jurisdiction and even by IP right. As an example, even within Canada, there's not a consistent rule as to the rights of co-owners of a patent vis-a-vis each other. So you can imagine the differences between different countries. So I would say generally licensing is more common, but not the only way to do things. Just switching to licensing now because I think it is a little more common. As I said before, you can slice and dice as you desire. You can divide by any of the drivers I identified earlier, exclusivity, revocability, whatever you want. You can have a royalty-bearing or a royalty-free license. And you can structure your royalties any way you want. An upfront license fee, a minimum annual royalty or some other period, a running royalty based on sales. You can gross up royalties to account for international withholding taxes. You can divide them by license term or geographic territory or by market segment and even by licensee, so royalties flow through. You can specify in an agreement whether or not the licensor or licensee are going to compete with each other. Related to that, you can specify who's going to own improvements developed by the licensor or licensee and whether or not there's going to be any cross-licensing back of those improvements. And this can be important because if you're a licensor licensing a key aspect of your technology and your licensee develops an improvement, you probably don't want that licensee taking that improvement and branching off and now suddenly using that to make your life a little more difficult. So often we'll see a license back of those improvements to the licensor. You can allocate risk in various ways. Indemnification, where one party promises to make the other party whole. For IP infringement, if the licensee is relying on the licensor for technology, usually there's some kind of indemnity. And vice versa, if you're the licensor and your licensee is using your technology to make products and selling those products around the world, particularly the litigation-happy United States, you probably want some kind of indemnity for product liability in case that liability would otherwise flow back to you. You can allocate risk by capping liability. If you are only making $1 million off a license, you probably don't want to have to indemnify for $50 million. So some kind of relationship there between the benefit you're getting and the risk you're accepting. You can control and accept input on patent prosecution. That is the process of getting patents between the parties any way you see fit. For example, if you're a licensee and you have an exclusive right to technology, you may care very much about protecting that technology in a certain way because it's a key competitive advantage for you. And you may want to be able to either control the prosecution of the patents or provide input to that prosecution at the very least. Related to that, again, if you're an exclusive licensee in particular, you may want to be able to directly enforce IP rights against third parties because as the exclusive licensee, your deal is you're the only one who has those rights. And if someone's infringing, you may not want the licensor to be able to just sit on its hands. And particularly important for SMEs, agreement assignment considerations. So as an SME, you don't want your hands to be tied in future rounds of financing or in an acquisition. So you want to turn your mind, should your agreement allow you without permission of the other party to assign the agreement in case all your assets are acquired or in case there's a change of control? Do you have to go and get a consent, which can be a bit of a pain in the context of a deal, or are you free to assign and transfer without consent? So those are the three things I wanted to talk about: the context for collaboration, supercluster sets, drivers, business-oriented drivers for collaboration, and some of the legal tools you can use to execute on collaboration. And that's it for my presentation. So Bill, I think I'll hand it back to you.
Thanks so much, Roch. That was a great presentation. And folks, just a reminder that if you have some questions for our Q&A session, just enter them into the chat box. And then what I'm going to do is I'm going to just share a brief presentation that will actually take us through some contextual elements as to how it applies to the supercluster. You know, I know that on this call we have many that are members and associates. In fact, I think just as a backdrop, now that we've gone through more than 50 projects in various phases in terms of contracting, some of which are actually up and running, some of which are in discussions and negotiations on the final contract, it's become more evident as to what is important in terms of the success metrics on building and designing an appropriate IP strategy and rationale. So I'm going to take you through a couple of slides here to bring us into practice. Just a quick reminder, you know, the supercluster was born out of the identification that we can actually do a lot more things together. And to the extent that we can bridge expertise areas across different organizations to assemble best teams to accelerate new solutions, that's really the purpose. And this whole collaboration framework hinges on building trust and collaboration amongst these players. And already we have, in fact, I think our latest count is close to 700 Canadian organizations ranging from startups, SMEs, large companies, multinationals, universities, research institutes, not-for-profits, government agencies, and we're quite pleased to see that so many of the new associates and members are coming from across Canada. We now have more than half of our associations or organizations that are coming from outside of BC. The strategy, for those of you who have been involved with our projects to date, you'll note that we have an IP strategy that was part of our arrangement with the Government of Canada when we set up the supercluster. And there are 5 core principles around our IP strategy. Now, one is to ensure that there are mechanisms to protect the value of background IP so that inherent in any collaboration, there is a sense of trust for the players that are coming into it, that nothing untoward will come to them as a result of collaborating on a project. The second principle is that there should be an alignment of what the foreground IP is going to look like and the strategy around that with what the commercialization strategy will look like. And that gets to some of the points that both Paul and Roch talked to earlier. And it's important to note that IP is really linked to the overall quest for commercialization outcome. The third area is that part of our strategy is to ensure that as a collective, the supercluster community has an opportunity to leverage the outcomes of this foreground IP in ways that benefit the ecosystem writ large. And that may be other players within the ecosystem, within the supercluster, but it's really to look for ways to really extend the maximum effect and impact of the investments that we're collectively making. And that ties to this notion of demonstrating value to Canadians. After all, the supercluster investment dollars are all coming from Canadian taxpayers. And so what we're trying to do is to make sure that we can position Canadian companies to really demonstrate the value out of these investments. And finally, I think it's really to, as Roch had showed in an earlier slide, is to level the playing field, augment the capacity, oftentimes that's missing in terms of what startups and SMEs have in IP expertise. So there is a framework that we operate on, and the framework simply is about building trust among the players. For us, it's facilitating the collaboration. But then when the collaboration teams come together and they start to build project proposals, inherent within the project proposal template is a section that talks about the IP rationale and exactly how they intend to go about working through the mechanics of the IP portion. And when we go through the project evaluation and selection, that is a critical piece that we look at. It's one of the criteria that we score against. It's one of the areas that in the history of the projects that we've evaluated, the determination of the success or failure of consortiums is whether or not they've had a fulsome conversation on the commercialization aspects and how they're going to treat IP. And all of that is embedded in the master project agreements, which, as many of you know, is a central document and a central agreement that binds all the parties in a collaboration. And so the IP rationale is baked into these master project agreements, and the performance mechanisms are all inherent in that as well. So there are three elements that are really essential in the IP rationale. Of course, the background IP, which is really about how project participants that contribute IP into a project are able to control, manage, and use their background IP in a manner that benefits the project while retaining the ownership that's inherent with bringing it forward. The second area is to ensure that the IP rationale addresses how the foreground IP is intended to be used, how the parties will have the opportunity to use or own or commercialize this foreground IP, and finally how it's leveraged. So leveraging the IP, as I mentioned, for the benefit of other opportunities that may be beyond this individual consortium, and where the access opportunities to use the innovation of the foreground IP might reside. I think the key for all of this, and Karima Banwatt, who's our IP manager, was previously the chief legal officer for BlackBerry. And if in addition to Roch and Paul, who have years and years of experience of dealing with IP, from a practical standpoint, the question is, how can you really design for success in these collaborations? And here are a few tips. You know, one is that you really need to start conversations early, the discovery process, for looking at where the complementary areas of expertise and where the IP sits. That's part of that whole ideation and developing the project. I think determining what the background, the framework for the background IP is important to do early, and to make sure, again, that your IP rationale really lines up with the commercialization strategy. They are not separated. They're kind of together in many respects. And as I mentioned, we have an IP manager, Karima, who is happy to work with project teams to help give you guidance as we go through that. So hopefully that gives a little bit of background in terms of how we see it from a supercluster perspective. And we're really pleased to see how many collaborations have actually unfolded. So maybe what I can do now is I'll take a look at and see how many questions we have on the chat board. It looks like we have quite a few coming in. That's fantastic. So maybe before I get to those, I know there were a couple of things out of Roch, your presentation in particular. I can link back to the presentation from Paul just to get us started. We have many recent members to the supercluster who are venture-backed organizations or they're angel-backed organizations. And oftentimes I hear the concern that's expressed about, well, how can I participate in supercluster in what way without compromising the integrity of my ability to raise additional funds, and how can I best guidance you would give to a venture-backed organization when it comes to participating in supercluster collaboration? Roch, do you want to start?
I'll start. So I think there are really two conceptual things to consider. One, during due diligence, for sure, you don't want, or you want to be able to, you want to be free to operate. So to the extent you are agreeing to particular license terms or ownership terms, I think you want to be careful not to impede your flexibility down the road. So for example, you may be doing a deal where as part of the deal, there's a license by market segment. And early on in your business plan, you may think that a particular segment of the market's not going to be that important. For example, maybe you're focused on businesses and not consumers. So you aren't that worried about only obtaining the right to sell to businesses. But of course, plans change, you may have to pivot. And if you do pivot, or a VC thinks you should pivot, and they do their due diligence and find that you can't because your license rights limit you to a particular segment of the market, that can be problematic. So I think the overarching priority there is make sure you have the rights you need to maintain your flexibility down the road. And I think second, once you've ensured that you can operate and you can do what you need to do, then I think your mind turns to how do you obtain the rights to exclude others from doing what you're doing? So an advantage over other competitors. And here it can be a little tricky because if the results of the collaboration are going to be free to license or what have you, then you got to think, okay, well, maybe I have to be a little careful about what aspects of my technology I participate or I make available. Maybe it's not your crown jewels, it's something a little less valuable where you're able to take a bit of a risk. And to Paul's point about, I think post-ground IP was the term he used, maybe there you think, okay, well, you know what, we don't want that to be licensed at all. We want that to be preserved because we're willing to expose ourselves in respect of collaboration for the stuff we've agreed to collaborate on, but stuff that we may develop a couple years down the road, maybe there we just need a license to the background IP or the foreground IP to give both parties a free hand to work going forward. But for the post-ground stuff, we don't want our future investors to have to worry about that. So I think to summarize, I think number one, you want to make sure you have the terms to operate yourself and be free to operate. And number two, then I think your mind turns to how to exclude others from competing with you. And that's going to go to the license terms. And if you can't get favorable terms, then to the value of the technology that you collaborate on.
Thanks very much, Roch. Paul, did you have anything to add?
Yeah, just a little bit. I completely agree with everything Roch just said. I think from the perspective of your business, you want to make sure that whatever you're giving up is not harmful down the road to your business interests. I left Gilbert's for a few years and was GC of a venture-backed hardware software startup. And I dealt with this issue a lot where, we were in a position where we wanted to collaborate as much as possible. But we only had a little bit of secret sauce. It's a small company. There's only a little bit that we actually can say this is ours exclusively, and this is the most important thing in our company. So making sure that we didn't give that up. And I think the key question ends up being the value of the partnership versus the value of being able to say that you're free from encumbrances or those business interests that Roch identified. I think, when it comes to purposes of acquisition or investment, a lot of acquirers or investors are more savvy now and are, I think a while back, the question was, is your IP encumbered in any way? If so, that's a red flag. Today, I think people are a little bit more savvy and they understand that if it's encumbered because you have a relationship with, I'm going to use Microsoft again, that can be a very positive thing. So I think these collaborations can be a really good thing for a venture-backed company in that sense.
Well, maybe on that, we can turn to some of the questions that are in the chat window, and I know we have a few more for the panel, so we'll come back to them if we have time. But we have a question from Adrian. Adrian, do you want to come off mute for a moment and maybe ask your question?
Thank you. So we're a recent associate to the Supercluster. We're finding that potentially our product is not quite ready for a big Supercluster project. So it feels like in order to reach that stage, we need to have a lot of research under our belt and a lot of proof that the product is working. So we're finding that we are working with a lot of research institutions. Just a bit of background, our product is basically a prescription for exercise. So it's a way of quantifying exercise and kind of removing the subjectivity of like how intense was that activity. And it works with wearables and heart rates. So you can imagine lots of hospitals, people just thinking about new ways of doing rehab or treatment. They're really interested in a technology that can quantify exercise. So my question is really, when you're working with these nonprofits and research institutions, what do they want out of it? And is it enough to just say that they've got a new tool in their belt that they can use? Do they just want to be able to access that data forever, and that any kind of innovation or IP that comes out of it to say this is the best way to treat this disease or this is the best program, can we still own that and they just get to use it for free? Is that enough of a win for them, I guess?
Okay, thanks for that question, Adrian. Roch or Paul, do you have either way you want to take that one?
I'll just quickly start off and say, I think think there's a very large range of what nonprofits and research institutions are looking for. I think the old impression was the unsophisticated nonprofit or research institution that's happy to just give you money to support the cause that they believe in or that they're advocating for or that they're researching, and don't have any commercialization interest or other interest beyond that. I think in more recent years, you see increasing use of things like march-in rights, non-exclusive licenses, the ability to sub-license to ensure that if the product of your work is not being put in the hands that the not-for-profit wants, that they have the ability to enforce that somehow or give it to somebody else to do. And I think you also see a bit of a commercialization aspect coming in as well, where some of these institutions and not-for-profits are looking for, sometimes modest returns, provided that they fall within the scope of their not-for-profit status. So, I've seen examples of that from Grand Challenges Canada here, from OCE in Ontario, the Ontario Centers for Excellence, and other models where grants and other kinds of funding are being provided, and those institutions are collaborating, but they're asking for some kind of ongoing royalty back.
Great, thank you.
Roch, did you have anything to add there?
Yeah, I think that's all correct. The answer will depend on the nonprofit. I think, very generally speaking, what have nonprofits asked for in the past? My short answer is I don't think they've asked for enough. And I think, so I think in the past, the focus was really on risk aversion. My experience was a lot of nonprofits weren't that concerned about revenue or commercialization. They were, they were more concerned about making sure, they would not incur any liability by virtue of indemnity or product liability than they were about generating the revenue. Just a 30,000-foot view. I think that's changing. I think it's changing for the better. I actually chair a local nonprofit, and it's nonprofit, not non-revenue, right? So we can generate the revenue and use it for purposes so long as there's no profit left. And I think what I've been seeing over the years is nonprofits becoming a little more savvy in that regard. But I think particularly because I would say we're still in a time of transition, you're going to see things across the board.
Great.
Yeah, thanks very much for that. And thanks for the question, Adrian, because I think at a practical level, the work that we've been doing with lots of nonprofits, we've seen a shift in terms of the quest for sustainability and the funding resources for lots of nonprofits and research institutes. So increasingly, they are looking at how they can benefit from some of the commercial outcomes. I think that's why it's important to ask questions like you have, because having those discussions earlier is the way to ensure that it's well taken care of, that there aren't any false assumptions that have gone into it from the beginning. So why don't we move to the next question? I think the next question, sorry, I'm just getting my screen here. Is that from, let's see, is that Samantha? Sorry, I can't read that. Annika, can you read the next question?
I think we have a question from Santiago, if you want to unmute your line and ask.
Thank you. Hello. I'm just curious about the role of open data and open data licensing around this intellectual property and how it all fits within that. I'm currently working on an open database, and so wondering how everything kind of fit around that. And sorry, I'm from Living Lakes, Canada, sitting for Kat Harwick here.
Right. Thanks for that question, Santiago. So, Roch, do you want to start with that one?
Sure. My experience with open data is that it's generally data that can be freely used for whatever purpose you want to use it for. So in that sense, if it's data that's been freely used, you can go ahead and use it without really without worry, but at the same time, it doesn't give you much of a competitive advantage because everyone else is also using it. So a variant of that is open source. My experience with open data has been that it's generally been made freely available. So there's no reason why you couldn't license it under some kind of open source type agreement. Just thinking out loud, although I haven't seen much of that in practice. Maybe that's an evolving market as well. And open source is a little more problematic in that there are some licenses that could be very, very troubling. The copyleft ones, if you were going to commercialize and raise funds later. But in terms of open data, yeah, if it's free to use, I think that's fine. Just keep in mind your competitors can use it as well. So it's not going to be a distinguishing factor for your business.
Yeah, I mean, I'll just say data raises a bunch of really interesting questions, particularly in a collaboration agreement. So, you know, obviously, maybe not obviously, but data presents some of the most difficult IP challenges. It's hard to lock down and protect in many cases. I'll just give a quick example. I worked on a data sharing platform for a group of collaborators. And in that case, they all had different interests, which I think it kind of maps onto the supercluster situation. There were some that were very pro-commercialization, and there were some that were pro-publication, not interested in commercialization whatsoever. And so, you know, one of the ways to break it down and to think about it were to take those people and divide them by their interests and see how you could get everybody where they needed to be. So everyone's putting data into the same data management platform. The people who want to patent or want to, you know, keep aspects of this secret for a certain amount of time for commercial advantage, we tried to make sure that they had time to accomplish those goals at the outset. You know, then we could move to a period where data could be shared within the collaboration, you know, and then following that, a period of open publication. So, you know, because at that point the cat's out of the bag, and like Roch was saying, once it's out, it's out. So, you know, this was the sort of way in which we moved and tried to align everybody's interests. One last thing I'll say in terms of data, you know, it raises other questions like where the data lives, data residency, the kinds of data stewardship, you know, and we've been looking at data trust to sort of manage some of that and to control the appropriate use, storage, and release of data within a collaboration. I think those are all important things to think about, even when you're thinking about it in an open data context. It's the timing and appropriateness of disclosures of data.
Thank you very much for both your answers.
Great, and Santiago, I think Evgeny Lukapotis, our CTO, is also on this meeting, and I know that I can channel that his comment would be that in some cases there may be derivatives of the data, there may be methodologies associated with how the data is used that may actually provide a framework for some protection in those instances. And I think to the extent that I know it's a very exciting project that you're involved with on the Freshwater Data Commons, and I think that there's all sorts of opportunities down the road for that consortium to build some capabilities there. So thanks for your question. Maybe we'll turn to the question from Al. Sorry?
Just wondering what the protocol is here for offering a contribution. Do I ask a question in the chat, or can I?
If you could, then that'll help us to kind of keep the queue operating.
Okay.
If you wouldn't mind, that would be great. Why don't we go to Alex? Alex, if you wouldn't mind unmuting and asking a question.
Yeah, so the question is very basic, trying to understand the landscape and what kind of help or assistance we can get from the supercluster on the IP matters. So we're new to the group, so therefore I just wanted to understand what we can get from the supercluster, what we can understand we can get from lawyers and other third parties, kind of paid service.
Thanks for the question, Alex. So as a supercluster, I think our capacity for providing a lot of support is pretty limited. So Karima works with us part-time to help project teams that are going through the negotiation aspects of their agreements and setting the IP strategies and agreements there. So we often turn to our partners like Gilbert's and Gowling's and other firms to provide more specific advice if it's pertaining to IP that you would be generating as a business. So we can certainly provide sort of the connections and the introductions to you and other organizations that are seeking that. I hope that answers your question. Evgeny, I think you had a comment, but I think I covered it. Is that right?
Yeah, we did. You did.
Okay, great. Okay. So Chris. if you wouldn't mind coming off mute.
Sorry for interrupting. I just wanted, I did another protocol. Just want to bring out that at the risk of being a slightly commercial, I'm one of those startups you mentioned. I work at Cinchi, and we're actually defined as a data collaboration platform. And I just wanted to share with the rest of, and I'm not saying we're the only ones in the world to look at, but I'm saying there are new ways to manage data that replace copying, which is also known as data integration, which is also known as data sharing, with access. So I think it might be really interesting for any projects that are concerned about that. If sharing and making copies of data is a concern and preventing collaboration, then there are purpose-built platforms, we being one of them, that have removed copies from the entire paradigm of building new technology. So you can actually work on a single universal set of data that has these embedded access controls that are defined by the data owners. And this is a very 180 on the entire, here's my data, don't do anything with it. This is, here's access to my data, I don't lose any ownership or control of it. Let's work together on this, on data blends, data models to create the technology we're trying to deliver. So there are alternatives, and this is new. I'm not suggesting anyone on this call would be overly familiar with it, but we work with, for example, TD Bank, RBC, CIBC, tens of thousands of users, all individual data owners in their own right in some cases, to work on internal technology. So there are alternatives to managing the risk of collaboration that is represented by data sharing.
Well, thanks, Chris. And that is actually exactly the Data Commons program that we have. So welcome to the Supercluster. It's great to have Cinchi as a new member on it. And I think a number of the projects, I think Freshwater Data Commons, Earth Data Store, and a host of the other projects are using exactly that paradigm, where it is more of a data commons network infrastructure, which doesn't require sort of movement of data. And so I think your point is very well taken about the new regime on how data is actually accessed and how it can be accounted for and in what conditions. So thanks for that comment. I think we're at the hour now. So maybe what I can do is invite Paul and Roch to make any final observations on this call. And maybe I'll start with Paul, if you want to make some final comments.
Sure, yeah. Just first of all, thank you, Bill. Thank you, Annika, and I'm not sure if Karima's here, but thank you, Karima, for having me here today. It's been a really fascinating discussion. It's obviously an area that we're really passionate about, so I hope all of you felt some of that joy and passion as well. And yeah, and you know, I really think what the Digital Supercluster is doing is extremely interesting, so happy to chat about any projects going forward. One last thing I'll just say, we've started putting out a series of papers on IP strategy, particularly targeted to collaborations. The content of my presentation today was the subject of the first one. The next one's coming out next week. If anyone's interested in receiving those, please feel free to get in touch with me.
Thanks so much, Paul. And Roch.
Yeah, thanks, Bill. I mean, thanks everybody for attending. I hope it was useful. If you have any questions afterwards, happy to answer them. If you want to learn more, particularly while everyone is on semi-lockdown, we've been hosting about as many webinars as you can imagine on various topics, all of which are recorded on our online platform, goxl.gowlingwlg.com. So if you have anything you want to learn about, I would say check out the platform, email me, happy to talk, and good luck with the collaborating.
Well, thanks again to Roch and to Paul. Fantastic comments. And who knew that we could make IP so informative and fun? But it was a fantastic session. And just maybe a reminder to everybody that we did record this session. And so we will be putting this up for anyone who was madly scribbling notes on some of the presentations that will be made available to everybody on this call through the recording that we did. And my final commentary is that this is part of a series of thought leadership workshops that we're hosting. I'm certainly going to take a cue from Chris's comment just now from Cinchi that we should do one around data and some of the network aspects of how data can be shared, and so we'll look to do that in the next little while. And if you have any feedback for us, please feel free to reach out to us at info@digitalsupercluster.ca. And again, I want to thank Paul and Roch for their insightful commentary, Annika for spearheading the coordination here, and Karima Bawa, who actually put all this together, was unable to join us as our IP manager, who actually made all this happen. So thanks again, everyone, and have a great Thursday.